And greetings. Welcome to Understanding Evidence, Admissibility. We're going to be going over some pretty good points here in a nice tutorial. And greetings to you too, Bill Thomas, all the way from Sonoma County, California. Let's proceed. All right. Give me a moment here. Get this zoomed in a bit more. All right, so let's get right down to it here. Understanding evidence. The key to understanding the rules of evidence is to see them classified into groups according to application. These are rules pertaining to hearsay, for example, and rules pertaining to relevance, privilege, and witness credibility. Our classification of evidence rules follows, and here's a nice list. And while everyone's coming in here, check the chat here. So what is this one here? There we go. All right. Yes, shalom, y'all. This is going to be a great subject. Yes, everyone's going to want this. It's not too long, but it's definitely succinct and to the point. So be sure to be taking notes. And please hit the like so word gets out that we're doing this here and everyone else can participate. Let's get right down to it. So here's a classification of evidence rules. Admissibility, which we'll be going over tonight. Judicial notice. Presumptions. Relevance. Privileges. Witnesses. Opinions and expert testimony. Hearsay. Authentication. Tangible evidence. Applicability. This tutorial takes each group in turn, explaining the nuts and bolts, simplicity of each group in terms you can understand and use. And that's how we'll be structuring these live streams here. We'll be going through each of these classes of evidence rules. We are going to examine evidence rules in a general way. This tutorial is not intended to be a substitute for official rules that control local courts. And I'll briefly mention it to everyone, this is not to be used for any purposes other than the educational entertainment broadcast here on YouTube tonight. Not to be used, construed for your personal, professional, legal, lawful, financial, or tax uses. Don't do this at home. Okay, let's proceed. This tutorial is not intended to be a substitute for official rules that control local courts. Check your rules of civil criminal procedure. We will examine rules of evidence only as they apply generally. The rules examined here may not be the same as the rules that control your local court. This tutorial is only a general discussion of rules of evidence as generally applied. Variations may exist in your local jurisdiction. For more information on evidence and specific rules that control local courts, consult your local library. And of course, you could also do that online now, I believe. It'd definitely be a source. What follows is intended only to explain in a general way how evidence rules are interpreted and applied. Careful study of this tutorial will help you interpret and apply the rules in your own case with reference to official rules that control your local court. Following an initial examination of the classification of evidence rules, the tutorial will provide tips on keeping your opponent's evidence out, getting your evidence in, and moving the court to consider all evidence in the best possible light for your case. All right, let's get down to it. And before we start on to the topic, double check on the chat here. Greetings to Audit Them. Yes, please hit the thumbs up, everyone. And let's continue. So, admissibility, one of the first rules. The most interesting and critical thing about evidence rules is how they apply to admit certain matters to be considered by the court and limit or exclude other matters. This first classification of evidence rules, therefore, deals with admissibility. A witness statement, for example, might tend to prove or disprove some of the issues in controversy. An example, it might be relevant to the outcome of your case, and yet be inadmissible for one or more reasons. Being relevant alone is not enough. Other factors must be considered before the court can determine if evidence is admissible. Each of these will be covered in detail during this tutorial. Some of those factors follow. Relevance, ability to prove or disprove an issue material to the outcome of the case. Credibility, that's the reliability of witness or tangible evidence. As they say, credibility is weighed, not counted. Privilege, protection afforded certain kinds of evidence. An example, attorney-client. Prejudice, tendency to confuse, mislead, or waste time. If a party offers evidence that is not likely to prove or disprove any issue material to the outcome of the case, not worthy of being relied upon as true, protected by privilege, or likely to cause prejudice that may outweigh its ability to prove or disprove any issue, it should be excluded as inadmissible, and an appropriate objection should be made as soon as possible, preferably before the court hears the evidence. Unless a matter is admissible, it should never be heard by the court. If it gets in by accident, the too frequent result of unlawful efforts of parties trying to get away with whatever the judge will allow, the matter should not be considered by the court. It should have no bearing on the outcome of the case. Of course, once it's in, it's in. More on handling improperly introduced evidence further on. Only admissible evidence should be considered by the court. Courts are called upon again and again to rule on the admissibility of evidence offered by parties trying to win their cases. The admissibility of evidence is ruled on at trial and all pre-trial phases of litigation as well, particularly including the discovery phase. It is, unfortunately, not all uncommon for unscrupulous lawyers to try to shift the court's attention away from relevant facts by introducing smoke and mirrors evidence that has no bearing at all on the outcome of the case, but tends to confuse both judge and jury. The savvy litigator is always aware his opponent will try to get in everything he can to muddy the waters and confuse the court. It is extremely important, therefore, to understand admissibility and how the courts rule on admissibility, because keeping the other side's evidence out is just as important and sometimes more important than getting your own evidence in. Federal Rule 1.02 suggests the purpose of evidence rules to secure fairness, the elimination of unnecessary expense and delay, and a means to ascertain truth and justly determine the outcome of judicial proceedings. The first step, therefore, is to determine admissibility of evidence, whether it should come in or stay out. All right, now we're going to get on rulings on evidence. And briefly, let's check on the chat here and see if how many people are in the house. If we are, definitely getting the word out here. Seems like we didn't get good notifications here. Slim audience. Nevertheless, it is Sunday. Let's just keep on going here. So, objections. You must object when inadmissible evidence is offered. You cannot allow it to come in then after you've lost your case, complain to the appellate courts that the trial judge should have excluded it. The rules simply don't work that way. You must object. You must object in a timely manner. You cannot allow a witness to keep on talking and object when it comes your turn to question the witness. You must object right then and there, on the spot, without unnecessary delay. Merely saying objection isn't enough either, unless the basis or ground for your objection is clearly apparent from the context, and you should never assume that it is. When you object to evidence being admitted, state your reasons. Cite the rule if you know it. Otherwise, explain the ground for your objection clearly. For example, if the lawyer on the other side is examining his own witness, he is not permitted to lead his own witness, but is required to elicit the witness's testimony by direct questions only. So, if he asks, "Isn't it a fact that you were walking your dog when the defendant attacked you with an umbrella?" That's a leading question. It's improper. And footnote 1 here says you are urged to obtain a copy from your jurisdictions. Differences are critical. Always refer to a recent copy of your official rules for your jurisdiction. You should jump to your feet quickly and say, "Objection, Your Honor, leading." That's enough to preserve your objection on the record for appeal, if the judge's allowing the evidence to come in is the cause of your losing. You should always object as quickly as you can, so the witness hasn't time to answer before you make your objection. If the judge is awake, your objection will be sustained, and the other side will be ordered to continue with direct questions only, as the rules require. Cross-examination example, using leading questions to interrogate a witness, is allowed only when you are examining the other side's witness or, in rare cases, where your own witness has turned hostile to your case. More on this later. Even though the rules allow objections to be made without stating the grounds if the grounds are apparent from the context, you are urged to state the grounds for every objection, so there'll be no argument later on as to whether the ground of your objection was apparent from the context or not. Remember, you cannot appeal a trial court's decision based on the judge's exclusion or admission of evidence if you don't timely object and state proper grounds for your objection. That's why understanding the rules of evidence is so critically important. Once a court rules on excluding or admitting evidence, and you make your objection and state proper grounds for your objection, you need not renew your objection, unless additional or different evidence is offered, in which case you must object again and state your grounds, or be deemed by the courts to have waived your objection. So, big lesson there, object in a timely manner, and make sure it's on the record to preserve your appeal. All right, let's double check on the chat and see what's going on here. Bilton says, "I understand the reasons, but it always seems sketchy when the judge instructs the jury to disregard what they hear." And by making a timely objection, it seems you can avoid that happening. So let's see here. Offer of proof. If you begin to offer evidence and, before you can get it before the court, the other side objects and the court sustains the objection, you must move the court to allow you to make clear on the record what the evidence was. This is called an offer of proof. If you don't get your evidence in and you don't offer the proof, you'll have nothing to appeal if the court rules against you, because a record will not show what evidence would have been. Therefore, when your attempt to get evidence in is prevented by the courts sustaining the other side's objection, all right, here's the action. Be sure to make an offer of proof stating what the evidence would have been and what you intended to prove by it. Then, if an appeal must be taken to the higher court on the basis that you were not allowed to get the evidence in, you'll have a record to show what the evidence was or would have been. In jury trials, offers of proof should be made outside the hearing of the jury. In some cases, this may be made at the bench, with the court reporter taking down every word spoken by the parties and the judge. Or the jury may be excused. It is common for the jury to be excused and for a party to be allowed to continue questioning a witness outside the hearing of a jury until the judge can determine if the evidence sought is relevant and not otherwise excludable. You can see how much prejudice would result if this offer of proof were permitted to take place within the hearing of the jury. Hearing of the court. It is entirely improper for a lawyer to ask questions he knows will elicit inadmissible testimony. It is against the rules in every jurisdiction. Federal Rule 102C is clear on the subject, stating that proceedings before the court should be conducted to the extent practicable to prevent inadmissible evidence from being suggested to the court by any means, such as by offers of proof, making statements, or asking questions. It is wrong. If it happens in your case, object loudly. Make your record. So, it's entirely improper to ask questions that the lawyer knows will elicit inadmissible testimony in every jurisdiction. If it happens in your case, object loudly and make your record. Sounds like sound advice. Making a record. All right. Remember that objections are only proper where the effect of failure to object would result in prejudice to a party's substantial rights. Objections are made to preserve those rights for appeal, as well as to prevent the court from hearing what it should not hear. Evidence that might tend to confuse the issues in controversy, mislead the court, result in undue delay, waste of time, or needless repetition. Objections are made to keep out what should stay out, to let in what should come in, and to establish a record in case an appeal must be taken on the basis that evidence was improperly admitted or excluded by the trial court judge. There is no other reason for objecting. So, making the record, reasons for doing this, of course, the rights for appeal. We don't want to confuse issues, waste time, undue delay, mislead court, controversy, needless repetitions, and objections are made to keep out what should stay out, let in what should come in, and to establish a record in case the appeal must be taken on the basis that this evidence was improperly admitted or excluded, either improperly admitted or improperly excluded by the trial court judge. So there is no other reason for objecting. Merely objecting for the sake of objecting or to disrupt the other side's train of thought, though too frequently practiced by unscrupulous lawyers, is contrary to both the letter and the spirit of the rules, and will result in getting you on the judge's bad side. Not good. All right. It is perfectly permissible to object when substantial rights are being threatened with real prejudice. An example, a consequence that may affect the outcome of the case. Make your record. Object timely and state your grounds for objection. However, to object for any other reason is improper and will work against you in the long run. What goes around comes around. All right, now we're on to preliminary questions. And before we go on to that, let's see what's in the chat here. So Bill Thomas says, if a case ends in a hung jury, can you still appeal inadmissible evidence to get a dismissal? I guess you're saying there. I would say that, again, by putting that objection on the record, it preserves that right of appeal. So the most important thing is to make your record, and object timely. From what I get from this tutorial here. Again, nothing here is to be construed as legal lawful advice for professional, personal, or any other means, and don't do this at home. All right, let's continue with preliminary questions. In determining admissibility of evidence, the court may rule on the qualification of a person to be a witness or the existence of a privilege. To reach this determination, it may be necessary for the court to consider facts that might not otherwise be relevant. An example, facts that relate only to the qualification of a witness or a relationship. An example here given is the attorney-client or priest-penitent. Wow, that gives rise to a privilege. In such cases, the otherwise irrelevant facts are permitted to be heard and generally will be heard by the judge with the jury removed from the courtroom. So that's your preliminary questions in determining the admissibility. So that's where you might consider these things, qualification of witnesses or relationships that give rise to privileges. Otherwise, irrelevant facts are permitted to be heard. So that's an interesting thing there, but that's only during preliminary questions, and the jury would be removed from the courtroom. Remainder of writings or recorded statements. If one party introduces any part of a writing or recorded statement, an example given here is a deposition transcript, audio or videotape recording, or affidavit, the other party may introduce any other part or all of the same that ought, in fairness, be considered at the same time. One cannot introduce part of such a writing or recorded statement and withhold the rest. The warning to consider is that if you have a deposition transcript with testimony in your favor, mixed with some testimony that is not in your favor, take care when you offer the party you want to come in, because by offering any part, you open the door to the other side to offer it all. Interesting here. So let's look at this warning again here. This is the remainder of writings or recorded statements. If one party introduces any part, right, the other party may introduce any other part, all the same, that ought in fairness be considered at the same time. The warning, though, is if you have a deposition transcript with testimony in your favor mixed with some testimony that is not in your favor, take care when you offer the part you want to come in, because by offering any part, you open the door to the other side to offer it all. Interesting concept there. So that's something where when we are looking at things, you got to look at them in their totality as evidence. Once it's admitted in part, the rest of it could be admitted by the other party in total, because if it is in all fairness to be considered, then they can introduce it as evidence as well. And if part of it is not in your favor, then that could basically nullify the part that is in your favor. So warning to the wise. All right, with that, we're on to the next topic, which we'll do on the next live stream to keep these brief and sectioned off for easy reference, which will be judicial notice next time. So with that said, I'd like to thank everyone for coming in tonight, going over understanding evidence and the rule of admissibility, learning this in depth, learning how to object, when to object, and why to object, when certain evidence should not be let in or should be and is being prevented from. So that being said, I want to thank you all for being here tonight. Salute to you all for going through this and spending your time here to learn something that can apply to our lives who knows when, but always want to be ready. I always say that preparation is the best form of prevention. And with that said, good night to you all, and I'll see you on the next one. Peace out.